Okay, so I'm going to share this and you can see my screen now.
Yep.
So let's start the slideshow. Okay, all right, so this is our presentation on the Divorce Act. That we are the Canadian Child Protection from Alienation Foundation. We're a national nonprofit aimed at various national goals. Our federal Divorce Act and our family law system is based on a federal system, so that's why we're a national. We started as a grassroots group on Parental Alienation Canada, just a grassroots community-based group, national, to, you know, kind of join together organically for this really important issue. And so we've evolved, we've incorporated, and we're planning to go into charity status eventually, but this is us. And we have a mission at CPAF. Our mission has four main points. Number one, we want to reduce the prevalence and impact of parental alienation and its consequences in Canada, partly by amending the Canadian Divorce Act, our federal Divorce Act. Number two, we want to develop awareness of mental health supports available to targeted parents and make sure that we can provide that education to targeted parents. Number three, want to educate about the harm of a for-profit adversarial family law system, which we have right now. It's totally for profit. It's not in the child's best interest. We want to also educate the public about alternatives to for-profit systems like an equal shared parenting default. And number four, we want to provide information and resources in schools and all of our institutions, including social work and psychology, everything. All of our institutions need to be informed. This is just a little bit about me so you know who the presenter is. I started the grassroots group in 2020 on Facebook. It seemed like the best place to build a community. There's a lot of targeted parents on there. I've been mentored by Amanda Sillers from the Eeny Meeny Miny Mo Foundation. That's an Australian nonprofit that I know. And I've also been mentored and instructed by the Canadian Centre for Men and Families, which is a national nonprofit, service-based nonprofit for men's issues, including men's suicide rates, domestic violence services for men and families, etc. Another thing about me is I've interviewed over a dozen experts about parental alienation and shared parenting and other, the other, the nuances of this issue. And you can find all my interviews on YouTube, on our YouTube channel. I also regularly interview, I take notes, and I coach parents that I talk to on the from our social media group, and so that's how I stay informed on how to do my advocacy. Also, sorry, and then what was? Let's see if I can go back one more. And I also read a lot of the literature and the studies that come out. I've also written op-ed and various responses to PA denial. I tried to bring all of my sources and then respond on a factual basis to whatever our opponents are saying to deny parental alienation. I'd
Can
like to
we make,
start you.
can,
Pardon?
oh, sorry. I'm sorry, I'm losing my voice. Can we make a couple of little comments that not necessarily now, but like once you send us the
Sure. Yeah.
document?
Yeah.
Okay,
Yeah. For sure.
okay.
So parental alienation refers to, I'd like to start with this definition, by the way, because a lot of people don't even know what parental alienation is. A lot of the audience that I present to, they never heard of it and they don't know what it is. So I like to define it. That parental alienation refers to the experience of a child who has been influenced to reject and hate one parent by the other parent and to parental behaviors that poison the child's relationship with the other parent. And it, can also be defined as or characterized as a form of programming of the child. It's an unjustified campaign of denigration against the parent, resulting in the child's own unjustified rejection of that parent. Now, the key point we want to make about PA to distinguish it from other dynamics like estrangement. Estrangement is when a child rejects a parent because they feel unsafe or they have been abused by that parent, right? What we want to know, what we want to say about PA is that we want to clarify that it's an unjustified rejection, right?
Yeah.
And what's interesting about PA and even children in foster care that have actually been abused, they frequently minimize the maltreatment of their birth parents perpetrated against them. So even when children have been abused, they still yearn to maintain a relationship with that parent. So
Mm.
for a child to actually reject a parent doesn't make any sense unless it's in the context of where they've been conditioned or they've been taught to do this by an alienating parent or some sort of, force that is telling them to reject their birth parent. They have to be conditioned. And there's a lot of misinformation that parental alienation is pseudoscience. I'm sure you've seen a lot of the propaganda the PA denial in the mainstream. But actually, we need to state that PA is evidence-based. It's absolutely evidence-based. Parental alienation is scientifically linked to child abuse, and domestic violence and false accusations. The clinical, legal, and scientific evidence on parental alienation has accumulated over the last 35 years. In fact, a full 50% of all the scientifically rigorous, peer-reviewed research has been generated and published since 2016. There are to date more than 1,000 peer-reviewed articles, chapters, and books that are published that affirm parental alienation, and the empirical research on the topic has expanded to a point that it has achieved a blossoming stage as a research field. So in 2016, I believe that was the beginning of the Parental Alienation Study Group. Bernays spearheaded that. And, with Harmon and many of these pioneers that started in 2016, now we've got this big boom of research coming out, 21st century research coming out. And so it's very well documented, but even before, anyone coined the term parental alienation, we can see domestic violence research going back decades and decades that show coercive control and use of children as weapons. So, it's an old dynamic that has long been documented, and it is evident. It is absolutely evidence-based. And so before we get into the Divorce Act, I just want to point out a few points about family law. Right now, like, why do things need to change? Well, it is a point that 75 to 80% of the suicides are male. And I can see anecdotally this is because of family law. I think it's a lot of it has to do with family law, the way that family law targets fathers and railroads fathers. It's, it would drive anyone to suicide. Also in family court right now, the alienating parents are uncooperative in potential resolution initiatives. They're not cooperating. The alienator parent is taking advantage, that creating drama and billable hours. They're taking advantage of that. Legal professionals maximize their profits by prolonging these cases. It is a for-profit industry, which is why we need an equal shared parenting default to stop lawyers profiteering. Legal and non-legal court-directed professionals are ill-equipped to manage alienation cases. This is a psychological, and these legal and court-directed professionals, they're not equipped to manage, to understand all the convolutions of parental alienation. They're not identifying at-risk children for this. And it's not uncommon for families to spend hundreds of thousands of dollars, if they have it, on what is called high conflict divorce, right? I feel like that's a misnomer, because high conflict, it implies that both parents are causing the conflict, when actually usually in this kind of in a parental alienation, it's only one parent that's causing an issue. We need to define what is the Divorce Act. How is family law organized in Canada? The Divorce Act is a federal act that governs divorce in Canada. The Constitution of Canada gives the federal parliament exclusive jurisdiction to regulate the laws of marriage and divorce. So each province in Canada implements family law within its own provincial family law jurisdiction based on the federal Canada's Divorce Act, right? So this is why we see PA deniers trying to change the Divorce Act, because this is like where the buck starts here, right? Or whatever, the buck stops here, whatever they say. So this is where our focus also needs to be on this federal legislation. So the current status of the Divorce Act. In 2019, we had a amendment, and the amendment was done with, the radical feminists and AWOL, and it was a gendered violence, and that was to include coercive control. And so they included that in the 2019 amendment, and that happened at that point. And it was, although not explicitly gendered, I'm saying that it was with a gendered to only target fathers as perpetrating coercive control, and they did not want to include anything where children could be victimized by women in some cases, right? So in considering the impact of family violence, the court is to consider, this is what their quote is, whether there's a pattern of coercive and controlling behavior in relation to a family member. They mean the father. Is the father doing this? So indirectly, the court presumes that the father is the only parent capable of abuse, according to the pseudoscience, the actual pseudoscience of gendered violence, right?
Right.
So let's go back. So that was 2019. That's our last amendment. And with this definition of family violence, it produces a non-exhaustive list of examples, none of which include parental alienation. So the examples of coercive control that were included in 2019 included forced confinement, harassment, including stalking, and failure to provide the necessities of life, psychological abuse, financial abuse, threats to kill or cause bodily harms, threats to harm or kill an animal or damage property or actually doing so. Gendered violence conveniently does not list parental alienation as a form of coercive control. So I don't believe they ever intended to. I think some people were very naive and they thought that this would apply to parental alienation, but I'm sure that was never their intention. The NAWAL is
Yeah.
NAWAL to do this. So now we come up to 2024, okay? And now it's explicit that they actually want to ban parental alienation arguments in family court. Now they're not hiding it anymore. This is a persecution against fathers, okay? And that only fathers could ever do coercive control. Women don't do this.
No.
Early in the 2024, National Association for Women in Law issues a press release that they're petitioning the justice minister to ban parental alienation arguments. And then NAWAL, this is Suzanne Secor, she's the head of NAWAL, claims that parental alienation is pseudoscience. So that happened in early 2024. Okay, so this is what they're doing now. So they're not only going to have, coercive control as they define it in the Divorce Act, not as, someone like us would define it, but as they define it as a gendered concept that only men do. Now they're also going to ban the PA arguments, and this is how this is their ideology, and this is what they're going to enforce on all of us through our federal legislation, right? So that brings me to Giancarlo. Okay, so I've been involved in men's issues, and I now have a gender neutral group. So I've been looking for solutions, and so as a group, a CPAF, I'm coming now to the solution that we need to perpetuate, right? And so I'm basing this off of Christine Giancarlo. She's an expert here where I live in Calgary. She's a former professor at the Mount Royal University. And she has done this exhaustive study on parental alienation and published it in her book, Parentectomy. It's a Canadian book based on the Canadian Divorce Act. And so I'm going to be presenting her two-pronged approach to workable solutions for the Divorce Act. We're finally going to address this in the parental alienation, and we're going to, grab this bull by the horn. So her approach is two prongs. So first of all, we have to preserve the parent-child relationship after a divorce or separation. And then we also need the second prong, we need to have interventions to resolve the established parental alienation. So these are cases that, the child's already been alienated. Now, how do we resolve this? So this is the two-pronged approach. So we're going to get into prong one, preserving the relationship, right? So to preserve the relationship, we need to implement a equal shared parenting default. This will help to mitigate 80% of the alienation, the mild to moderate cases, and it also help a lot of families with financial destruction because if they don't need a lawyer, this is going to be an equal shared parenting default. In 80% of the cases, it's going to be fine. The couple divorces or separates, equal parenting must be the default law, right? So as Dr. Amy Baker, she's an expert from the US, as I brought up, she says that 80% of alienation, mild to moderate, will be resolved by an equal shared parenting default. This is because the system is encouraging alienation. If one parent has all the power to the medical records, one parent has the unilateral power to tell the other parent they can't pick the child up from school. If both parents have equal power in the system and equal access to the child, that will by default resolve the mild to moderate cases of parental alienation. As I said, save many families from financial destruction as well. And the research and the literature that we have on shared parenting and what kind of results this gets for children, the literature shows us that whether the couple relationship is high conflict or not, children will continue to benefit from maximum contact with both parents. So we want to buffer the child from the conflict between their parents by preserving that relationship after they're still, if they had a good relationship with both parents before the divorce, now there's still that continuity after the divorce and there's no disruption of their relationship, then the child will stay stable. And this is what we want for children, is to maintain that continuity of the relationship and not interrupt their relationship as much as possible after this divorce or separation. The divorce is between the parents and not between the child and a parent, right? And of course, the default will be rebuttable with proof of child abuse. If there's we're not talking about false accusations just to get upper hand in court, but if there's like real proof of child abuse, then we do need to have a custody dispute and lawyers involved, obviously. But if both parents were fit before the divorce, then both parents will be considered fit, and there'll be due process for that, right? We want to have due process so that both parents, if they're fit before the divorce, we're only taking people's kids away if there's actually proof that they're not fit parents. We want an equal shared parenting default. Sorry, I'm just going to go back one because it's well documented about the wonderful benefits of having an equal shared parenting default and that continuity on every metric that you can think of, like the child's psychological outcomes, how well adjusted they are psychologically, their school performance, sports performance, music performance, anything that you can think of that measures a child's well-being, they will do better. And it increases with the parenting time at 50-50, maximizing time with both parents. So there, this is from the International Conference on Shared Parenting. That's an international conference on all the literature and the scholarship on shared parenting. And this is their statement from 2023. There's a consensus that shared parenting is a viable post-divorce parenting arrangement that is optimal to child development and well-being, including for children of high conflict parents. The amount of shared parenting time necessary to achieve child well-being and positive outcomes is a minimum of 1/3 time with each parent. So that we need to have a minimum of 1/3 time with each parent, with additional benefits accruing up to and including 50-50 for parenting time, including both weekday routine and weekend leisure time. So as I said, that's from the International Conference on Shared Parenting. That was their statement on 2023. And so equal shared parenting. So if it's not possible to have 50-50, for example, if one parent already traveled a lot for work and that was already the situation before the divorce, if one parent was, constantly away, then we want to have a case of shared parenting. We don't want to remove a parent. Maybe we could do Zoom calls or like have some other way for that parent to still spend time parenting their child after the divorce, whatever we need to do. We want to have a commitment to maximizing the time for both parents, regardless of the situation. So co-parenting and child focus, not maximizing the profits for litigation, right? So I'm just quoting Brian Ludmer here. He's an Ontario-based lawyer who is also an expert on parental alienation, and he's pointed out how inappropriate it is to impose a litigation model on a family dynamic like a divorce. It's very unhealthy. It's just common sense that it's very unhealthy, and you don't sue people in your family. You're trying to work out something equitable for your family, right? So, and then the second part of it, so after we have the ESP, we're gonna be needing some way to actually enforce something. So we've had lots of like laws before, but we need some way of enforcing the legislation or the decisions, right? And so we're gonna have to implement something like an access enforcement program that'll be mandated by the federal government and established by regional or provincial governments. So as I said, mandated in the Divorce Act, and then it is the regional and provincial government's responsibility to actually implement this on a provincial level. And what we want is if either parent or grandparent or other extended family member or other knowledgeable about that particular couple's relationship dynamic history, we want that party that suspects that the parents are unable to co-parent effectively. We want that party to report the set of parents to the access enforcement program. So if anyone in the whole family dynamic sees that they're not co-parenting, the child is at risk, then we want that party to report them to this newly established access enforcement program. Through the AEP, the program will assign a parenting coordinator or a family justice committee. Now, this is where I'm kind of digressing a little bit from Giancarlo's book but she's seen this and she approves this.
Okay.
So I've done an interview with Vernon Beck. He's a parenting coordinator in Ontario, and he has designed this idea of a family justice committee. I mean, I think some smaller locales and smaller towns wouldn't be able to have a local parenting coordinator to manage the family unit until the children reach the majority age. But I think we could train, at CPAF, we could get Vernon Beck we could get a training program to train local volunteers to manage these cases for their community. And the thing is that a lot of these parenting disputes that we see after divorce or separation, it's over things that are like parenting situations that don't require litigation. You don't like right now, everybody's going and hiring a lawyer if they're angry the example that Bernard Beck has is about feeding your child too much sugar, like parents disagreeing about candy, or are you going to hire a lawyer to argue about the chocolate bar that you're feeding your kid at lunch? You know what I'm saying? So that's what's happening right now, and the lawyers love it because this is all billable hours for them. But Vernon Beck is saying, hey, we can just train local community members for family justice committees to work a lot of this out for kids, right? If their parents are fighting about the candy bar, A lot of these family justice committees can work out these parenting, and then we could train that, and then this could be family justice committees that are local trained and volunteer based, and people could bring their case, whatever their issue is, their parenting, co-parenting issue, and then it could get worked out to be fair and have justice for the child in that situation, right? More about the access enforcement program. So if either parent is not co-parenting, we want to have mental health assessments for required for both parents. Because if someone is not co-parenting, basically the alienator could have a cluster B personality disorder, need to be diagnosed with that. And also the targeted parent's going to have some trauma and some PTSD from being a targeted parent, right? So we want to have mental health assessments of both parents in the best interest of the child. We want to make sure that it needs to be done by mental health experts with the knowledge of cluster B. So they need to know what is a sociopath, like they need to understand these dynamics. Sociopath, a lot of alienators and severe ones are narcissists, and some of them have borderline. Okay, and the mental health expert also needs to understand the convolutions of parental alienation. Okay, we can't have any more ignorance about parental alienation. We need to have mental health experts that actually understand this. And if one parent is an alienator, the targeted parent will receive temporary full custody of that child or the children. And this is all evidence based because we have studies that show that it is not traumatic to remove a child from an alienator. It is not traumatic to remove the child from an abuser, which is what they are, right? The alienator is an abuser, and the child will reattach. A normal child will reattach. The attachment dynamic will as soon as they're removed from the abuser, they will reattach to that targeted parent. So this is not a problem, and so that's what we need to do if this is happening. If we discover that this is happening. So access enforcement, we want to have each parent work full time. If they're both getting 50-50 custody, both parents, we want to have both parents working full time to we don't want to have a sexist, dynamic where one parent is expected to provide all the money and then one parent is just changing diapers, basically, right? So we're going to have both parents parenting and both parents working. There might be some exceptions for parents with small children. Like I know, like if someone's like a really small child, got a really small child, maybe the mom needs to be home and they don't want to send their child to daycare, right? But in most cases, we want to have each parent working full time. So the AEP will be directly tied to the maintenance enforcement program the purpose of this is that, for all of this is we don't want to have a financial reward to withhold the access from the breadwinner, whoever's providing, more money. We don't want to have one parent withholding access and then saying that they're entitled to more money because they're doing this. We want to discourage this. Child maintenance will be determined using a table based on the net income difference. So Christine's example in her book is when the mom is making $100,000 and the dad is making $80,000, then in that case, the mom would transfer $10,000 to the dad so that the child would enjoy an equal standard of living in both houses. And that's what that's about, right? And like I said, we're not gonna have a financial incentive to withhold a child. We want the child to enjoy maximum time with both parents. And in all cases with no history of abuse or neglect, the children's right to both parents will be the overarching priority. Now I know there's some other cases like, there's other, and I know there's some, cases where a mom might have like 5 different dads or something, and we have to have it like, but there's different calculators, but generally this is what we're going to do is have a net income difference. Excuse me. Sorry, I had to sneeze there. Okay, so that was prong one when we're doing the prevention, and now we're getting into the interventions for established parental alienation. Okay. So instead of having this illegal concept, what we really need to do is make this a mental health priority. And we need to so through CPAF, we're going to train all mental health, legal professionals, and educators. They must be trained to recognize and identify at-risk children. The reason why that PA, this Parental Alienation Study Group, submission to the DSM, I believe it's been blocked for political reasons, not because of lack of evidence. Okay, so there is a DSM submission. We need to support this so that we can make this an actual mental health issue. Excuse me. So that's the key here is that it's going to be a mental health concept and not a legal concept anymore. We want, if it's a mental health priority, then professionals must refer children to access enforcement program. We're going to start mandating this and asking teachers, we're going to train them and teach them to recognize these at-risk children and start, and reporting this when it's a problem. When parents are not co-parenting, this is going to be considered a problem. And another part of this is that since we want family law, since they're not, they're trained to be lawyers or judges, they don't really understand all the convolutions of mental health and how to recognize, every dynamic that goes on, all the convolutions. So we're going to restrict family law, okay, to their mandate of property divisions and parenting schedules and enforcement of the mental health directive. So the family law is taking the directive from mental health, and family law is not assessing mental health, okay? We need to inform judges and lawyers. They need to understand how PA harms children because right now they're not getting it. They don't see the trauma. We need to inform them and help them understand that this is harming children. And as I said, it's going to be the mental health professionals are going to provide the directive. It's not going to be lawyers and judges providing the directives anymore. There'll be two cases. If a parent is an alienator, the one case would be that they're mentally unfit. This is number one. And then the second case would be that they're fit, but they're just vengeful or, they've got, or greedy, right? So this is mentally unfit. If we discover that the alienating parent is mentally unfit by the coordinator or a mental health professional or the AAP, the alienating parent must submit to a psychological assessment. Ideally, both parents will submit to that. Alienated children remain temporarily in the primary custody of the targeted parent. And we still want children to visit with the alienator. We still want the children to have a relationship with both parents. But they'll be supervised visitation with the alienator at that point. And then with treatment, we want the alienator to earn back 50-50 unsupervised custody as mandated by the revised Divorce Act. Because we understand that children benefit enormously by having a 50-50 relationship as much time with both parents as they can. And so that we want to treat the alienator if they have a mental cluster B personality disorder, we want to help them earn that 50-50 unsupervised custody, get them to that point. Number two, as I said, they could be vengeful or they could be greedy. So if the alienator does not have a cluster B personality disorder, but they're just like subclinical, but they're greedy or they're vengeful, the court will order an access enforcement program and it's going to be paid for by the alienator, not the targeted parent. So we want to have the financial, if someone is an alienator and they're not cluster B, then that's going to be, they're going to be fined. Penalties such as fines and even jail time may be enforced, right? We also don't want parents showing documents like about the conflict. We don't want to adultify children. So we're going to have penalties if parents are showing documents about the conflict or you're talking to the children about an infidelity and showing them anything like that. That's going to be considered child abuse, and so we won't be enabling that any longer. We need to discontinue the concept of a mature minor where you're thinking that a child can, the child will stay up all night playing video games. The child will eat ice cream for every single meal. So the child cannot make decisions about their own care. So that's why the responsible adult has to step forward and we're going to make the decision for the child based on their actual best interest, right? And I'm not talking about in every single matter. I'm not educated on mature minor label for every single situation, but I'm talking. This is in the context of parental alienation. Okay, we don't want children making their own decision because in Alberta, the concept of mature minor has led to countless brainwashed, alienated children being released into the custody of this functional harmful parent because they've been coached by this, and they said that, well, I can make my own decision, right? They're 15 and they can make their own decision, and they can't because they go into the custody of this. They stand up for their abuser. They lie for their abuser, right? We need some regulation once this happens, right? So the AEP parenting coordination can be regulated by a third party, and I would say that maybe CPAF could be mandated by the federal government to regulate and train family justice committees. We could do that with our our advisors helping us do these provide the regulation that's required and train the family justice committees. I also want to touch on Kira's law because this is another piece of legislation that's not our Divorce Act, but it is a PA denying law. It's based on it has passed and it's being mandated into our provincial family court with a gendered violence. That's the pseudoscience of gendered violence. This is to cherry pick and to it's altering legal policy on the basis of males being more prone to lethal child abuse. This is just nonsense. Okay, this is our mean here. That of the study of the largest study ever done on child murder and child abuse, it showed that 60% of the child deaths were perpetrated by the mother. So to formulate all of our laws based on this concept of this cherry-picked Kira's Law case, it doesn't make sense because actually mothers murder and abuse kids more than men do. That's just a fact, right? So that's something also that needs to change is this Kira's Law. Just wanted to sum this up, saying that there's other documentaries and books that you can find to inform yourself about parental alienation and also shared parenting defaults. We have the Erasing Family documentary. It's available on YouTube. It shows the financial and the emotional costs of our for-profit family court system, and it also shows the shared parenting system in Sweden. So I recommend that you look at that Erasing Family documentary. You can get Christine Giancarlo's book Parentectomy. It's a Canadian-based book on the Divorce Act and how it fails children. And there's also academic research groups such as the Parental Alienation Study Group. So these are some great resources that you can find. And then I also encourage you to, celebrate with us on April 25th, the International Day of Parental Alienation Awareness. And we raise the flag in Canadian cities and we wear royal blue. So yeah, so that's my presentation and I will
Very
just
good.
stop the